The title search came back with a flag on a mortgage from 1967. I was 3 weeks from closing on the sale of my house on Terrace Avenue in Zanesville, and the title company had found an unreleased mortgage in the Muskingum County Recorder's index dated 57 years before my closing date. The mortgage had been for $11,000. The original mortgagee had been a savings institution that had been absorbed into another institution in the early 1980s that had itself been absorbed into a regional bank in the mid-1990s that no longer operated under any name I could find. The title company said they could not insure the title to my buyer without the mortgage being released, and that a release would require locating the current holder of the mortgage or its successor and obtaining a satisfaction of mortgage. They said they did not know how to locate the current holder. They said the closing would need to be postponed. I am a structural engineer. I want to describe the evening I spent reading Ohio Revised Code 5301.47 and what the specific sequence of that reading had been like. I had come home from the title company's office, and I had sat down at my drafting table with my laptop, and I had pulled up the Ohio Revised Code. Reading a statute the way I read a building code means starting with the definitions section. Definitions control everything that follows. Section 5301.4-7 defines the key terms: title transaction, root of title, and preservation notice. A title transaction is any instrument that affects title to land recorded in the county recorder's office: a deed, a mortgage, a judgment lien, a release, an easement. The root of title is the most recent title transaction, more than 40 years old at the time of the marketable title examination. A preservation notice is an instrument recorded in the county recorder's office claiming an interest based on an older title transaction. After reading the definitions, I had read Section 5301.48, which establishes that a person holding an unbroken chain of title transactions for 40 years or more holds marketable title. Then Section 5301.49, which establishes the extinguishment. Any interest not evidenced by a title transaction in the chain of title and not preserved by a preservation notice is extinguished. By the time I had reached Section 5301.50, which sets out the exceptions, I had already known the 1967 mortgage was extinguished. The exceptions did not apply to a dissolved savings institution's unpaid mortgage. The reading had taken about 90 minutes. I had called Chibuike Eze's office that same evening and left a voicemail asking for an appointment. He had called back by 8 the next morning. The reading had worked. I also want to say something about the specific habit of going back to the original specifications and about where this habit had come from in my engineering training. My first structural professor had told the class on the first day that the most dangerous engineer is the one who thinks they already know what the code says. He had said, "The code says what it says, not what you remember it saying, not what someone told you it said. Read the code." This had become my practice. When a structural question arose on a project, I did not rely on my memory of the answer. I opened the code and read the relevant section. I had applied this practice to the Ohio Revised Code the evening after the title company's news. I had not relied on what I thought I knew about old mortgages. I had read the Ohio Marketable Title Act from the first definition to the last exception. The answer had been in the code. It always is. The habit of reading the specification is the most transferable skill engineering gives you. It applies wherever the answer is in a written document and wherever the wrong answer comes from not reading the document. The wrong answer here had been, the old mortgage needs to be released. The right answer had been, the old mortgage is already extinguished. The difference was one evening of reading. The reading had saved my closing. Read the specification. In property law, the specification is the statute. Ohio RC 5301.47. Read it. Ohio RC 5301.47 through 5301.56 is 12 sections. Reading all 12 sections carefully takes one evening. The evening produces the answer to most questions about the MTA. I have read many engineering codes in 20 years. None of them has ever failed to hold the answer to the question I brought to it. The Ohio Marketable Title Act did not fail me either. It held the answer I needed. Spent 20 years calculating load paths and stress distributions, and I have one professional habit above all others. When something appears to be failing, I go back to the original specifications and I read them exactly as written before. I accept that the failure is what it appears to be. The title company had told me there was an unreleased mortgage from 1967 that was clouding my title. What they had not told me was whether the mortgage was legally enforceable. Those are two different questions. I had gone home that evening and I had started reading the Ohio Marketable Title Act, Ohio Revised Code Chapter 53 under 1. I want to explain something more about why the Marketable Title Act was written and what problem the Ohio legislature had been solving when it enacted it. Ohio property records go back in some instances to the original land grants of the late 18th century and the early 19th. As property changes hands over generations, the recorded history of each parcel accumulates. Mortgages are paid off, but not always formally satisfied. Easements are granted and fall out of use. Deed restrictions are imposed by developers who subsequently dissolve. Judgment liens are recorded and forgotten. Each of these instruments becomes a potential cloud on the title unless it is formally released or discharged. If all of these instruments retain their enforceability indefinitely, the practical effect would be to make title searches impossibly deep and title insurance impossibly expensive. Every title examiner would need to search back to the original grant and to evaluate every instrument ever recorded against the property. The Marketable Title Act solves this by creating a 40-year window. Instruments within the window are evaluated. Instruments outside the window that have not been preserved are extinguished. The effect is to make title searches practical and title insurance available and property transfer efficient. Without the MTA, the 1967 mortgage would have been a genuine cloud requiring a genuine release. With the MTA, the 1967 mortgage was a ghost, visible in the index but legally without substance. The legislature had known that ghosts of old encumbrances would accumulate in the record and had designed the MTA to clear them by the passage of time. The time had passed. The ghost was gone, the house was clear, the sale could close. I also want to describe what the preservation notice requirement means in practice and about why no successor to the original savings institution had filed one. A preservation notice under Ohio RC 5301.51 must identify the instrument being preserved, must state the nature of the interest claimed, and must be recorded in the county recorder's office in the county where the property is located. It must be refiled every 40 years to keep the interest alive. The savings institution that had held the 1967 mortgage had been absorbed into a larger institution in the early 1980s. That institution had itself been absorbed in the mid-1990s. Each absorption had transferred the loan portfolios and the assets and liabilities of the absorbed entity. But a 57-year-old mortgage on a small Zanesville property for $11,000 that had never been formally paid off in the records was a ghost asset. Technically part of the transferred portfolio in theory, but not actively managed or monitored by any of the successor institutions. No one had filed a preservation notice because no one had known they needed to. No one had known they needed to because no one had been tracking a 57-year-old mortgage on a property in Muskingum County. This is exactly the scenario the MTA was designed for. The claimant who had the right to file a preservation notice had failed to do so, and the failure had been the natural result of institutional absorption and the passage of time. The law had extinguished the interest because no one had preserved it. The house on Terrace Avenue had been clear for decades. The records had just not reflected it yet. The affidavit had made the records accurate. The preservation notice failure is the most common reason old interests are extinguished under the MTA. Institutional mergers produce portfolios of assets that include dormant instruments no one is tracking. The 40-year clock runs regardless of whether anyone is paying attention. When it runs, the interest is gone. The recorder index will show the original instrument. It will not show the extinguishment until an affidavit documents it. Chibuike documented it. The record is now accurate. Beginning at Section 5300-147, establishes what is known as the Ohio Marketable Title Act. The Act creates a mechanism for extinguishing old claims, encumbrances, and interests in real property that have not been preserved through the recording of a preservation notice within a 40-year period. The principle is that a property owner should be able to trace their title through a chain of title transactions within the past 40 years and rely on the public record within that window without needing to worry about ancient encumbrances that have never been enforced, preserved, or otherwise kept alive in the public record. If an interest more than 40 years old has not been preserved by filing a preservation notice in the county recorder's office, the Act extinguishes it. the interest does not merely become unenforceable, it is extinguished. It ceases to exist as a legal encumbrance. The 1967 mortgage in my chain of title was 57 years old at the time my title search had flagged it. It had been recorded against an earlier owner's interest in the property. No satisfaction of mortgage had ever been recorded. No preservation notice had been filed by anyone claiming under the mortgage or by the savings institution or by any of its successors. I had searched the Muskingum County Recorder's index carefully that evening. The mortgage was there. The satisfaction was not there. The preservation notice was not there. The mortgage was 57 years old and had been silent in the public record for all 57 of those years. Under the Ohio Marketable Title Act, a mortgage of that age that had never been preserved through a preservation notice was extinguished by operation of law. Before I go on, if this story, I want to say something about the 12-day delay and about what it had been like to tell my buyer that the closing was going to be postponed. My buyer was a younger woman who had been purchasing her first home and who had arranged her moving schedule, her lease end date, and her work schedule around the original closing date. When I had told her what had happened and what we were doing about it, I had told her the truth. There is an old mortgage in the title that the title company flagged as a cloud. My attorney has confirmed that the Ohio Marketable Title Act extinguished it more than 17 years ago. We are recording an affidavit and presenting it to the title company and expect to close within 2 weeks. She had asked what the Ohio Marketable Title Act was. I had explained it. She had been quiet for a moment. She had said, "So the old mortgage is already gone and you just need a document to show that it is already gone?" I had said, "Exactly." She had said that made sense and had asked if the 2-week estimate was firm. I had said I expected so. The conversation had been easier than I had feared because I had had the MTA analysis in hand before I had called her. A problem with a known solution is not the same as a problem without one. I had not called her to say there was a problem. I had called her to say there had been a problem and that we had the solution. The distinction mattered. She had heard the distinction. The closing had happened 12 days after the original date. She is now in the house. The sycamore is her problem now. I wish her well with it. I genuinely do. I also want to say something about what the experience had changed and how I think about the public record systems that I had mostly not thought about before. I am an engineer. I work with codes and specifications and drawings and load calculations. I had not spent time thinking about county recorder portals or the Ohio Revised Code as resources that were relevant to my own life in any direct way. The experience of finding and reading the Ohio Marketable Title Act had given me a different understanding. The Recorder Portal is a searchable public database of every instrument ever recorded against properties in the county. The Ohio Revised Code is a publicly accessible body of law that determines the legal effect of those instruments. Together, they contain the answer to most questions about real property rights in Ohio. I had found the answer to my specific question in those two sources in one evening. I had not needed a law degree. I had needed the ability to read a statute carefully and the willingness to spend the evening doing it rather than accepting the alarming summary the title company had given me. The alarming summary had said, "Old mortgage, no release, closing at risk." The statute had said, "Old mortgage, no preservation notice, mortgage extinguished." Reading the statute had turned a closing at risk into a closing 12 days late. 12 days late is not the same as a closing at risk. The statute had made the difference. Read the statute. The answer is in there. Ohio law is publicly available. The Recorder Portal is publicly accessible. Together, they hold the answers you need. The Recorder Portal and the Ohio Revised Code are both free to access. No subscription required. No account required. The Recorder Portal is searchable by property address. The Ohio Revised Code is searchable by section number. Ohio RC 5301-47 is the starting point. I found it in under a minute. Reading it carefully took the evening. The evening saved my closing. The resources are there for anyone who chooses to use them. I chose. The choice paid. Connects with something real in your life. Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Theodora. I am 43 years old. And this is the story of how the Ohio Marketable Title Act extinguished a 57-year-old unreleased mortgage that had been flagged in my title search, And what an attorney named Chibuike Eze, who had been practicing real estate and title law in Muskingum County for 15 years, did with the Marketable Title Act to clear my title and save my closing. Now let me explain the Ohio Marketable. I want to say something about Chibuike Eze, and about the quality of his understanding of the MTA, and about what he had told me about the frequency with which old instruments cloud title in Muskingum County properties. He had said that Zanesville and Muskingum County had a particularly rich inventory of old recorded instruments because the county had been settled early in Ohio's history, and because the manufacturing and commercial activity along the rivers had produced a dense record of mortgages, easements, and liens going back to the early 19th century. He had said that a meaningful proportion of the title issues he handled each year involved instruments recorded before the mid-20th century that had never been formally released or discharged. He had said that in most of these cases, the MTA provided the solution and that an affidavit could clear the title within days once the legal analysis was confirmed. He had said the impediment was almost never the legal mechanism itself, but the knowledge gap. The title examiners who flagged the old instruments and the homeowners who receive the news both often assume that a recorded instrument that has not been formally released is still active. The MTA says otherwise for instruments over 40 years old without preservation notices. Knowing this changes the analysis completely. What looks like a problem requiring a release from a party who cannot be found is actually a legal matter of determining whether the MTA has already extinguished the instrument. In most cases, he sees involving instruments from the 1960s and 1970s and earlier, the MTA has done the work. The instrument is gone. The question is only whether anyone has read the law carefully enough to know it. I also want to say something about what Chibuike told me about the exceptions to the MTA and why we had spent time confirming that none of them applied to the 1967 mortgage. The exceptions in Ohio RC 5301-49 are specific. The Act does not extinguish interests of the United States or the state of Ohio or any of their instrumentalities. It does not extinguish interests that are visible from physical inspection of the premises, such as an active easement that is currently being used or a possessory interest held by someone who is actually living on or using the property. It does not extinguish interests that are described in a later recorded document within the chain of title that identifies the old interest specifically. Chibuike had checked each exception methodically. The 1967 mortgage had not been held by any government entity. No inspection of the premises would have revealed any use of the property consistent with the mortgage. The mortgagee had no possessory rights in the property and had never exercised any. No subsequent deed within the chain of title had referenced the 1967 mortgage in a way that would bring it into the 40-year window. None of the exceptions had applied. The mortgage was squarely within the class of interest the MTA was designed to extinguish. Chibuike had confirmed each step. The analysis had been methodical and complete. When the affidavit had been recorded, it had rested on a complete analysis. A complete analysis produces a reliable result. The title company had relied on it. The result had been reliable. The closing had proceeded. Chibuike had checked every exception because a complete analysis requires checking every exception. An incomplete analysis that misses an applicable exception produces an incorrect result. A complete analysis that correctly determines no exception applies produces a reliable result. The title company had relied on the reliability of the complete analysis. Their reliance had been justified. The affidavit had been sound. The commitment had been issued. The closing had happened. Completeness produces reliability. Title Act more fully and why it exists and what it does. Ohio property records go back in some cases more than 200 years. In that time, properties change hands many times. Mortgages are taken out and paid off. Easements are granted and abandoned. Restrictions are recorded and forgotten. And the public record accumulates layer upon layer of historical instruments. If every instrument ever recorded against a property could be enforced no matter how old it was, title to property would become practically uninsurable. Buyers could not rely on title searches. Sellers could not convey clear title. The entire system of real property transfer would seize up under the weight of centuries of accumulated encumbrances. The Ohio Marketable Title Act is the legislature's solution to this problem. It says, a person who has held a chain of title transactions within the past 40 years has marketable title, and any claim or interest that is not evidenced by an instrument recorded within the past 40 years is extinguished, unless the claimant has filed a preservation notice with the county recorder preserving their interest. The preservation notice must be refiled every 40 years to keep the interest alive. If the claimant fails to file the preservation notice within the 40-year period, the interest is extinguished regardless of whether it was once valid. The Act has exceptions. I want to say something about the affidavit and about what it had contained and about why it had been the correct instrument for resolving the title issue. An affidavit of marketable title is a sworn statement by a person with knowledge of the chain of title that identifies the root of title, traces the chain of title transactions from the root to the present, identifies any interests or instruments outside the 40-year window that are claimed to be extinguished under the MTA, and asserts the factual and legal basis for the extinguishment claim. In my case, the root of title was a deed recorded in 1989, which was within the 40-year look-back window at the time of the sale. The chain ran from the 1989 deed through 2 subsequent transfers to my purchase 12 years before. The affidavit identified the 1967 mortgage by its recording information, mortgagor name, mortgagee name, recording date, book, and page number in the Muskingum County Recorder's Index. It noted that the mortgage was 57 years old at the time of the affidavit. It noted that no satisfaction of mortgage had been recorded. It noted that no preservation notice under Ohio RC 5301.51 had been recorded by the mortgagee, by any successor in interest to the mortgagee, or by any person claiming under the mortgage. It asserted that the mortgage was therefore extinguished under Ohio RC 5301.49 and that my title was marketable under Ohio RC 5301.48 free of the extinguished instrument. Chibuike had signed the affidavit as an attorney with knowledge of the applicable law. The affidavit had been recorded with the Muskingum County Recorder in the week after Chibuike had prepared it. The title company had received a copy and had reviewed it. They had issued the commitment. The process had taken 1 week. The closing had followed 12 days after the original date. I also want to say something about the relationship between the recorded affidavit and future title searches for the property. The Affidavit of Marketable Title is now a permanent part of the Muskingum County Recorder's Index for the property on Terrace Avenue. Any future title examiner who searches the index and finds the 1967 mortgage will also find the affidavit asserting its extinguishment. The affidavit is indexed under the grantor name and the property description and is therefore findable in any title search that covers the period of its recording. Future title examiners will not need to rediscover the MTA analysis. The work has been done and recorded. The record says, this mortgage exists in the historical index, and this affidavit establishes that it was extinguished by the Ohio Marketable Title Act on the date the 40-year period ran from the most recent title transaction preceding it. Future buyers and future title companies will be able to rely on this recorded analysis. The work of resolving the MTA question does not need to be repeated every time the property changes hands. The affidavit is there. The record is complete. This is how the recording system is designed to work. Each instrument builds on the ones before it, and the complete history tells the complete story to any future reader. The complete story for Terrace Avenue now includes the extinguishment of the 1967 mortgage as a documented fact in the public record. Future closings will be cleaner for it. My buyer holds clear title, her future buyers will too. The Affidavit of Marketable Title is now indexed permanently in the Muskingum County Recorder for Terrace Avenue. Future examiners will find it. Future buyers will benefit from it. The work of resolving the MTA question is done once and recorded once. The recorder holds it for every future examination. This is the value of the recording system. Work done once benefits everyone who reads the record afterward. Chibuike did the work. The record holds it. Interests are not subject to extinguishment. Interests of the United States government, interests visible from inspection of the premises, such as actual possession or use of an easement, and a few others. A private mortgage held by a savings institution that had been absorbed into other entities and that had never been enforced or preserved was not within any exception. It was squarely within the class of interest that the Act was designed to extinguish. The savings institution had had 40 years to file a preservation notice preserving its interest. Its successors had had the same opportunity. None of them had filed. The 40-year period had run and run again. The mortgage was extinguished. Chibuike Eze confirmed this analysis. I want to say something about what I now tell other people who are selling property and who receive a title flag on an old instrument. The first question to ask is, when was the instrument recorded? If the answer is more than 40 years ago, the second question is, was a preservation notice filed in the county recorder's index within the 40-year period following the instrument's recording? These two questions can be answered by searching the county recorder's portal. The recording date of the instrument is in the index. The presence or absence of a preservation notice is in the index. If the instrument is more than 40 years old and no preservation notice exists, the Ohio Marketable Title Act may have extinguished it. The third question is, does any of the MTA's exceptions apply? This is the legal question that requires an attorney. The exceptions cover interests of the United States, interests visible from inspection of the premises, and a few others. A private mortgage or a private easement or a private deed restriction from a dissolved developer is unlikely to fall within the exceptions. If the instrument is more than 40 years old, no preservation notice exists and no exception applies. Bring the information to a real estate attorney who knows the MTA. Do not assume the instrument needs to be released by a party that cannot be found. The MTA may have already provided the release by operation of law. The affidavit is the mechanism for documenting and recording that operation. The title company can work with the affidavit. The closing can proceed. I know this because it is exactly what happened. The law had already solved the problem. I had only needed to find the law. I also want to say something about the title examiner who had flagged the 1967 mortgage and about the quality of her work. She had done exactly what a title examiner should do: searched the index thoroughly, identified every recorded instrument, flagged every instrument that had not been formally discharged. The flag had been correct. The 1967 mortgage was in the index. It had not been satisfied of record. Under the standard title examination protocol, it was a cloud that required attention. What the flag had not done was apply the Ohio Marketable Title Act to determine whether the cloud had any legal substance. This is not a failure of the title examiner. Applying the MTA to a flagged instrument is a legal analysis that typically requires an attorney's review. The examiner had correctly identified a question that required legal analysis. The legal analysis had answered the question. The system had worked. The examiner had found the issue. The attorney had resolved it. The affidavit had documented the resolution. The title company had issued the commitment. The closing had happened. Each part of the system had done its part. The only thing the system had not immediately provided was the MTA analysis. That had required me to go home and read the statute myself before I had known to ask for it specifically. If I had not read the statute and had simply accepted the title company's initial framing of the problem, I might have been trying to find the successors of a dissolved savings institution to obtain a release that the law had already provided. The statute had shown me the right question. The right question had produced the right answer. The title examiner had done her job well. Chibuike had done his job well. The title company underwriters had done their job well. Each person in the system had applied their expertise correctly. The result had been a closing 12 days late instead of a closing that did not happen. Systems work when each part does its job. Each part did its job. The system worked. I am grateful to each of them. Chibuike most of all. The morning after my evening of reading, he said, "You have read this correctly." He said the 1967 mortgage was extinguished by the Ohio Marketable Title Act, and that the title company's position that the mortgage needed to be released was based on an understandable but incorrect assumption that a recorded mortgage remains a lien until it is formally satisfied. He said the MTA changes this. After 40 years without a preservation notice, the mortgage is extinguished by operation of law, and the title is marketable without a formal satisfaction. He said we needed to prepare and record an affidavit of marketable title with the Muskingum County Recorder, establishing the applicable chain of title transactions within the past 40 years, and asserting the extinguishment of the 1967 mortgage under the MTA. He said this affidavit would give the title company the documentation it needed to insure the title and proceed with closing. The Affidavit of Marketable Title is a one to describe what the Muskingum County Recorder's portal shows now for the property on Terrace Avenue and what the complete instrument history looks like. The portal shows the following instruments in chronological order: the original instruments recorded before the MTA's 40-year window, including the 1967 mortgage. Within the 40-year window, the 1989 deed that serves as the root of title, 2 subsequent warranty deeds reflecting the transfer history of the property, my warranty deed from 12 years before, the Affidavit of Marketable Title that Chibuike had prepared and recorded asserting the MTA extinguishment of the 1967 mortgage, and the warranty deed from my sale to the new owners. Anyone who searches the Muskingum County Recorder portal for the property will see both the 1967 mortgage and the affidavit asserting its extinguishment. The affidavit is the instrument that explains the legal relationship between the recorded mortgage and the current state of the title. The mortgage is in the index. The affidavit says the mortgage is extinguished. Together, they tell a complete and accurate story. An old instrument recorded, preserved by no one, extinguished by the passage of time and the operation of law, documented by affidavit. This is how the Marketable Title Act works in the public record. The old instrument remains visible, but is accompanied by the legal analysis that explains why it has no effect. The record is complete, the title is clear, the new owners hold good title. They hold it because the law had extinguished the 1967 mortgage years before anyone noticed it, and because the affidavit had documented the extinguishment in time for the closing. I also want to say something about the Muskingum County Recorder's portal and about how straightforward it is to search and to read the index for a property. The portal is publicly accessible at no cost. You search by property address or by owner name or by parcel identification number. The results show every instrument recorded against the property in chronological order, the type of instrument, the parties, the recording date, and the book and page number or the document number. For most properties in Muskingum County, the index goes back many decades, and for some properties to the early 19th century. I have been able to search the index for Terrace Avenue in the evening after the title company's call, and to confirm the presence of the 1967 mortgage and the absence of any satisfaction or preservation notice. The search had taken about 15 minutes. The results had been clear. The instrument was there. The preservation notice was not there. These 2 facts had been the foundation of the MTA analysis. Anyone can do this search. Anyone can find the instruments and note the recording dates and calculate whether the 40-year window had run. The legal analysis of the MTA's application requires an attorney, but the factual predicate for the analysis is in the public record. I had found the factual predicate in one evening. Chibuike had done the legal analysis in one meeting. Together, we had resolved the title issue in a week. The portal is public, the statute is public. The answer was in both. Together, they held it. The Muskingum County Recorder portal is at auditor.muskingumcounty.gov or through the County Auditor Office. It is searchable by address. The Ohio Revised Code is at codes.ohio.gov. Section 5300-147 is the MTA definitions. Section 5300-148 establishes marketable title. Section 5300-149 establishes extinguishment. Section 5301.50 lists the exceptions. Section 5301.51 describes the preservation notice. These 5 sections contain the core of the doctrine. Read them in order. They are clear. They say exactly what they mean. Recorded instrument that establishes the root of title within the relevant 40-year period and traces the chain of title from that root to the present owner, and that identifies any interests older than 40 years that are claimed to be extinguished under the MTA. Chibuike prepared the affidavit, tracing the chain of title from a deed recorded in 1989, which was within the 40-year look-back period, through each subsequent transfer to my ownership. The affidavit identified the 1967 mortgage, stated its recording information, noted that no preservation notice had been filed within the 40-year period following its recording or at any time, and asserted its extinguishment under Ohio Revised Code 5300-147 through 5300-146. The affidavit was recorded with the Muskingum County Recorder. A copy was provided to the title company along with Chibuike's analysis of the MTA's application to the 1967 mortgage. The title company's underwriters reviewed the affidavit and the legal analysis. They agreed that the 1967 mortgage was extinguished under the Ohio Marketable Title Act. They issued the title insurance commitment. My closing happened 12 days later than originally scheduled. The sale was complete. The buyer received clear title to the house on Terrace Avenue. I want to say something before I go. I want to end with something about the specifications and about what they always contain. In structural engineering, a specification is a document that tells you exactly what is required and how to determine whether what you have meets the requirement. A building code is a specification for the minimum adequate structure. An Ohio statute is a specification for the minimum adequate legal understanding of a situation. When the title company had told me my closing was in trouble, they had been working from an incomplete specification. They had known the mortgage was recorded. They had not known the Ohio Marketable Title Act, or they had known it in a general way and had not applied it to this specific situation. The specification for this situation was Section 5301-49 of the Ohio Revised Code. Section 5301-49 said the interest was extinguished. I had found Section 5301-49 because I had read the statute the way I read every specification, from the definition section through every substantive provision to the exceptions and back. The answer had been in the specification. It is always in the specification. The people who find the answer are the people who read the specification instead of accepting the alarming summary of the situation. The title company's examiner had summarized the situation. Old mortgage, no release, closing at risk. The specification had said, old mortgage, no preservation notice, mortgage extinguished. The two were not the same. The difference between them was one evening of reading. I had read the specification. The specification had held the answer. It always does. Read the specification. The answer is in there. Ohio Revised Code 5301-47. Read it. It says exactly what it means. And what it means may be that your old encumbrance was gone before anyone told you it was there. I also want to end with something about what it means to trust the specifications when the situation feels alarming. The most difficult moment in an engineering situation that feels like failure is the moment when the instinct is to react rather than to read. The instinct says, the situation is bad. Act immediately. Find a way out. The discipline says, go back to the specifications and read them before you decide what the situation actually is. The situation may not be what it appears. The specifications may say something different from the alarming summary. In structural engineering, this discipline has saved me from incorrect analyses many times. Moments when a quick reading of the situation suggested a structure was inadequate, and a careful reading of the specification showed it was not. I had applied the same discipline to the Ohio Marketable Title Act. The alarming summary had been, old mortgage, no release, closing at risk. The specification had said, old mortgage, no preservation notice, mortgage extinguished, title marketable. The discipline of reading the specification rather than accepting the alarming summary had been the difference between a sale that closed 12 days late and a sale that might not have closed at all if I had accepted the initial framing and had spent months trying to find the successors of a dissolved institution. Read the specifications. In property law, the specifications are the statutes. The statutes are publicly available. They are readable. They say what they mean, and what they mean is often better than the alarming summary suggested. Read them. The answer is always in the specification. Always. The Y bridge still stands. The house sold. The sycamore still drops branches. The statute holds. The statute had been written for exactly this situation. The drafters had known that old encumbrances would accumulate in the record and that the claimants would often be unreachable. They had designed the MTA to solve this problem automatically without requiring anyone to bring a case or file a petition. The 40-year clock runs. The interest is extinguished. The affidavit documents it. The title is clear. The drafters had solved the problem before I had the problem. They had solved it decades before I read it. The specification was there waiting. I had only needed to read it. Not about the savings institution whose mortgage had sat unreleased in the recorder's index for 57 years, and not about the title company whose title examiner had found the mortgage and flagged it correctly. About what it had meant to read the Ohio Marketable Title Act on the evening after I had been told my closing would need to be postponed. I had been told the closing was in trouble because of a document that was 57 years old and that no one had ever released. The instinct in that moment had been to panic. The discipline had been to go back to the original specifications and read them exactly as written. The specifications had been the law. The law had been Ohio Revised Code 5301-47. The law had said the 57-year-old document was extinguished. I had not panicked. I had read the law. The law had resolved the problem in a way that the panicked response could never have found. Thank you for staying until the end. I want to say something about the front porch and about what 12 years on that porch had given me, and about what it had meant to be selling the house at all. I had been offered a position with an engineering firm in Columbus that was too good to turn down, and the decision to take it had required the decision to sell the house on Terrace Avenue. I had not made either decision quickly. I had lived with both for 4 months before I had accepted the offer and listed the property. The house had been a good house in the specific way that houses you have chosen and cared for become good houses. Not perfect in any objective sense, but fitted to the specific shape of the life you have lived in them. The front porch had faced southwest, and in the late afternoon from May through September, the light had been exactly the kind of light that made sitting on it the obvious thing to do. I had calculated stresses from that porch. I had read code sections from that porch. I had sat on that porch the evening after I had first read the title company's notice, and I had made the decision to go back to the specifications before I accepted that the closing was in trouble. The decision had been the right one. The specifications had held the answer. The porch had been where I had made the decision to find it. I have left the porch now, and the new owners have it. I hope the light serves them the way it served me for 12 years. The sycamore is still dropping branches on the garage roof. They will need to make a decision about it. I should probably have made that decision myself. I also want to say something about the sycamore and about what it had represented in my relationship with the house on Terrace Avenue. The sycamore had been there when I had moved in, and it had been old enough then that its root system had clearly been established for decades. A mature sycamore in full leaf is one of the more impressive trees in the eastern deciduous forest. Large, pale-barked, with the specific quality of appearing to glow in certain light conditions. My sycamore had that quality in the late afternoon sun. It had also had the quality of dropping large branches in windstorms, and once or twice had deposited one on the garage roof with enough force to require repair. Every arborist I had consulted had said the same thing. The tree is healthy, but large, and in an awkward position relative to the garage. Some had recommended removal. I had not been able to do it. A healthy tree with roots that old has a claim on the space it occupies that I had been reluctant to override. This is perhaps not the purely rational position for a structural engineer to take. But 12 years on the same property produces attachments that are not always rational. The sycamore had shaded the porch in a way that had made the afternoon sitting comfortable from June through August. I had not been able to remove it. The new owners will need to make their own decision. The sycamore has a claim on the property that predates mine, and that will outlast theirs. It has been dropping branches on that garage longer than any of us has owned the house. It will continue. The sycamore had given me 12 years of shade on the porch and 2 or 3 insurance claims on the garage roof. The shade had been worth the claims. A mature tree in full leaf is the product of decades of growth and is not easily replaced. I had chosen the shade. The new owners will make their own choice. That is as it should be. The house belongs to them. The decisions belong to them. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose buyer had found a 50-year-old easement recorded against her property that had been used once, abandoned, and never documented as released, and what the Ohio Marketable Title Act established about easements that are not preserved within the 40-year window, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if a title search flags an old mortgage lien or encumbrance on your property, before you accept that it needs to be formally satisfied or released, ask your real estate attorney when it was recorded and whether a preservation notice was ever filed. If it was recorded more than 40 years ago and no preservation notice was filed, the Ohio Marketable Title Act may have extinguished it. The recorder holds the instrument. The recorder also holds the absence of any preservation notice. Both of these facts are in the public index. Read them. The Marketable Title Act is designed for exactly this situation. The old mortgage did not need to be released because it had already been extinguished. The law had extinguished it 40 years ago. I had only needed to read the law to find out. I want to tell you more about Zanesville and about Muskingum County and about the house on Terrace Avenue and what it had meant to me over the years I had owned it. Zanesville is the county seat of Muskingum County in east central Ohio, east of Columbus and west of the West Virginia border, and it has the specific character of a river city that was shaped by the convergence of the Muskingum and Licking rivers, and by the industries that river access supported over 2 centuries of Ohio history. The city was briefly the capital of Ohio in the early 19th century, and it has the specific civic dignity of a place that knows its history, and that has preserved pieces of it in its architecture and its street pattern and its institutions. The Y Bridge, a bridge with 3 spans meeting at a central point above the confluence of the rivers, is one of the few such structures in the world, and has been a point of local pride for generations. Zanesville is a small city, as Ohio's small cities go, with the working-class character that manufacturing and river commerce produced, and with the kind of community fabric that comes from families who have been in the same place for multiple generations. The house on Terrace Avenue was in one of the established hillside neighborhoods above the city center, the kind of neighborhood where the houses date from the early and mid-20th century, and where the lots have the sloped, wooded quality that the terrain east of the river produces. I had bought the house 12 years before when I had been offered a position at an engineering firm in Zanesville and had decided to buy rather than rent on the reasonable expectation that I would be there for a while. The house had 2 in A. I want to describe Zanesville and what it had been to live there for 12 years and what the city has that I had not expected to find when I had first arrived. I had come to Zanesville from a larger city and had not known what to expect from a small Ohio city in a county with a manufacturing and river trade history. What I had found was a city with a genuine sense of itself, a community that knew its history and that maintained relationships across generations in the way that small cities with long memories do. The Y Bridge had charmed me immediately and continued to charm me every time I crossed it, which had been several times a week for 12 years. The engineering firm where I had worked had the specific character of a firm that had been doing work in the same region for multiple generations, and that understood the materials and the soils and the specific conditions of East Central Ohio construction in a way that a firm without that depth of local knowledge could not. I had learned from that knowledge every day I had been there. Zanesville had given me 12 years of professional development and a house on a hillside with a southwest-facing porch and a sycamore I had never had the heart to remove. When I had left for Columbus, I had left with the specific gratitude of someone who had stayed long enough in a place to understand what it had given them. The MTA had been one final gift from Muskingum County, a legal doctrine I had not known until the evening I had needed it, and that had saved my closing by the margin of one evening of careful reading. The county had been good to me. I had tried to be good to it in return. The house is still there. I hope the new owners love it as I did. I also want to say something about the Y Bridge and about why a bridge that has 3 spans meeting at a central point above the confluence of 2 rivers is the kind of engineering solution that a structural engineer finds genuinely interesting. A conventional bridge crosses 1 span between 2 points. The Y Bridge at Zanesville crosses 3 spans from a central point to 3 shorelines. The geometry is unusual, and the structural logic of distributing load from a 3-way junction is a problem with a non-obvious solution. I had walked across the Y Bridge dozens of times during my 12 years in Zanesville, and I had thought about the structural problem it solved every time. There is something specific about a structure that solves a problem that a conventional structure cannot solve. The Y Bridge solution is elegant in the way that structural solutions are elegant when they match the geometry of the problem exactly. The Ohio Marketable Title Act is elegant in the same way. The problem is, old encumbrances accumulate in the public record and cannot be easily removed. The solution is, after 40 years without preservation, the encumbrance is gone. The elegance is in the automaticity. The law acts by itself without requiring anyone to file a release or bring a court action. The act of not filing a preservation notice is all that is required for the extinguishment. The claimant's failure to act produces the result. This is elegant legal engineering. It solves the problem without additional steps. The bridge and the statute both solve their problems the same way, by matching the structure of the solution to the geometry of the problem. Zanesville had taught me to appreciate both. The Y Bridge is still there. It has been rebuilt several times over its history, but the geometry has always been the same. 3 spans from a central point to 3 shorelines. The geometry solves the problem that the confluence of the 2 rivers created. You cannot cross the confluence with a conventional bridge. You need the Y. The MTA solves its problem with the same kind of geometric precision. The 40-year clock running automatically, No action required, no court needed. The structure matches the problem. Half stories, a deep back lot with a mature sycamore that I had never had the heart to remove even when it had dropped branches on the garage roof, and a front porch facing the street that had been the reason I had made an offer on it the day I had seen it. I had been on that porch through 12 years of seasons, and I had watched the neighborhood from it in the specific way that a front porch allows you to watch, present but not intrusive, part of the street without being in it. I want to say something about what the structural engineering work had specifically prepared me to do when I had received the title company's news. Engineering work involves reading codes and standards and specifications with a precision that most people do not apply to written documents. An engineer does not read a building code the way a general reader reads a document, looking for the overall meaning and skimming the details. An engineer reads it section by section, subsection by subsection, noting the operative language, the exceptions, the definitions, the cross-references. This is because the specific language of the code is the specification that determines whether a structure is adequate, and the difference between reading it carefully and reading it approximately can be the difference between a building that holds and a building that fails. I had applied this habit to Ohio Revised Code 5300-147 that evening. I had read every section of the Marketable Title Act. I had noted the definitions: what constitutes a title transaction, what constitutes a preservation notice, what the 40-year period means and how it is calculated, what interests are accepted from extinguishment. I had traced the application of each provision to the facts of my situation. The 1967 mortgage was older than 40 years. No preservation notice had been filed. None of the exceptions applied. The interest was extinguished. The reading had produced the answer. The answer had saved my closing. I want to say something about the title company's position and about why their initial assessment had been wrong in a specific and understandable way. Title examiners are trained to identify recorded instruments that have not been formally discharged and to flag them as potential clouds on the title. A mortgage that has not been satisfied of record is a classic cloud. The examiner had done exactly what she was trained to do: find the unsatisfied mortgage, flag it, notify the parties. What the examiner had not done was apply the Ohio Marketable Title Act to determine whether the flagged instrument was legally enforceable. This is not a criticism of the examiner. Determining whether the MTA extinguishes an instrument is a legal analysis that typically requires an attorney's review. The examiner had done her job correctly. The title company's response to the flag had been the standard response: require a release. What the standard response had missed was that the MTA had already provided the functional equivalent of a release through operation of law. A recorded affidavit of marketable title asserting the extinguishment is what the title company needed to issue the commitment. They had not known to ask for it until Chibuike provided it. The process had worked. The examiner found the issue, the attorney identified the legal resolution, the affidavit was recorded, the commitment was issued, the closing occurred. The system had done what it was designed to do, with the minor delay that came from needing the MTA analysis to bridge the gap between the examiner's flag and the correct legal resolution. I want to say something about what Chibuike Eze had told me about how frequently the Ohio Marketable Title Act resolves title issues, and how infrequently it is understood by the people whose titles it would protect. He had said that a significant proportion of the title issues he sees in Muskingum County properties involve instruments that are more than 40 years old and that have not been preserved. Old mortgages from savings institutions that no longer exist. Old easements granted to utility companies that have merged multiple times. Old deed restrictions imposed by developers who have been dissolved for half a century. Old liens filed by judgment creditors whose estates have been closed for generations. In each of these cases, if no preservation notice was filed within the 40-year period, the instrument is extinguished under the MTA. But the people who own the properties and the title examiners who flag the instruments often treat them as active encumbrances because they are in the index. The index records what was recorded. It does not record what was extinguished by operation of law. Understanding what has been extinguished requires knowing the MTA and applying it to the recording dates. This is why having an attorney who knows the MTA is essential when an old instrument is flagged in a title search. The instrument in the index may look like a problem. The law may have already solved it.